trade and services agreement, as we've heard, is intended to go beyond all existing multilateral and bilateral agreements and be part of the constellation of agreements currently being negotiated that extend far into areas that have never been recognized as trade-related. The seismic shift this represents is summarized in an article by Jonathan Comer, who is a former U.S. Trade Representative, deputy official with the U.S. Trade Department. He titled his article, "Not Your Father's Trade Agreement," to alert us to this seismic shift that is happening, where measures that are entirely within countries' borders are now being disciplined. And so we're no longer talking about easing controls at the border, as was pointed out earlier. The kind of differences the kind of changes that TISA will be accomplishing, according to Jonathan Comer, is that it will be going after differences in regulations between governments, and that would be between governments, like between the U.S. and European Union, or within, like, the cantons in Switzerland or the provinces in Canada. So any differences will be targeted. So that obviously, if one regional government is innovating with environmental legislation, then that will be disciplined. Localization requirements, and that's, again, the instance of data being required to be stored locally. Restrictions on cross-border flows, data flows, so enabling services to be provided across borders. And then here we have him saying that government influence and control of services will be disciplined under TISA, which is basically a very, very radical agenda that speaks to, it's supposed to be an ambitious agreement, and that would be very ambitious to get government influence and control over services eliminated. The context for TISA is what Thomas McGarity has called laissez-faire revivalism. There was this post-1970s campaign to roll back consumer safeguards, worker protections, and environmental protection regulations that were introduced in some countries in the 1970s. Regulations in a very sophisticated media campaign, regulations became characterized as unnecessary, unnecessarily burdensome, unduly burdensome, unduly complicated, as restrictions on rights, on corporate rights. And the language of these anti-regulatory campaigns have been picked up in trade agreements, especially in CETA, which I'm guessing will be the model for the domestic regulation disciplines in TISA. And the difference between the GATS and TISA, the GATS, you got the foot in the door to this disciplining of non-discriminatory regulations, but it was a mandate to negotiate any necessary disciplines. So they actually don't have to come up with any. They can decide that the disciplines aren't necessary. But in the draft disciplines they've come up with at the GATS negotiations, you have incredibly broad definitions of what they're trying to discipline. So basically anything that's even related to a license or a licensing procedure will be captured. So I don't know what regulation wouldn't be captured by that. The negotiations at the GATS have been controversial over the degree of severity of the disciplines, so you have a range of proposals. And one of them is that there should be a necessity test, and this may appear in TISA as well. So again, in terms of the level of ambition for deregulation, we have this statement from Samuel D. Piazza, who's the chair of the Services Lobby that's basically initiated or really got TISA going. D. Piazza says that through TISA, TISA members should either modify or eliminate regulations And the accomplishment of TISA should be to have free market principles govern the investment in and delivery of services on a transnational scale. So you're looking at not only the privatization of services, but the elimination of those privatized services regulations. So it's basically a 1-2 punch. You're both obligated to privatize under the coercive negotiating structure, but then you're not really going to have full reign to regulate those privatized services. And in terms of specific sectors, under distribution, this is another quote from testimony given by the corporate lobbies on TISA, testimony to the U.S. Congress. Sarah Thorne from Walmart says that TISA should protect retail and distribution rights. So this is establishing corporate rights and basically putting regulation and public interest regulation on the back foot. With no limits on size, geographic location. So I'm used to work in urban planning, so when someone says that there's not going to be any limitation on geographic location, that's a frontal assault on municipalities' right to regulate. That's what they do. They limit where you can put a Walmart, among other things. And Walmart's also seeking the elimination of restrictions on merchandise. So they're saying tobacco and alcohol could be freely distributed through any Walmart or any retail outfit with no government regulation. Other sensitive products that are covered obviously are guns and ammunition. So I don't know what the regulations are in Europe, but you can buy guns and ammunition freely in Walmarts in the United States. So I guess they're looking for that here too. So again, we're stuck with the dilemma of talking about something that we haven't seen. So how do we know that these very broad corporate demands are going to be met? Well, we know that TISA has a chapter on domestic regulation, so it's no longer a negotiating mandate. And we know that there's going to be a top-down structure to TISA for commitments, for national treatment commitments, to use the jargon. Under the GATS, anywhere that you make a commitment, then the domestic regulation disciplines kick in. So, for example, in the education sector, you may already have opened up your education sector to private suppliers, but then you think, well, why not just put it in the agreement in exchange for something else? Why not make a national treatment commitment? But what negotiators may not be thinking about is what will that mean for their right to regulate in the education sector. For example, you may want to regulate private suppliers in terms of how much they can charge, or how many of them there are, or what the quality of the service they supply is, or are they required to post a bond if they may abscond basically with tuition fees. So there's a whole range of regulations of private education that will be disciplined if countries commit what they've already opened up. So possible grounds for TISA challenges to regulations, we can either have the necessity test, which would mean that if challenged, a regulation would have to be proved to be necessary, and there's a very long, complicated jurisprudence on that that I'm not going to go into, but Sonia said that the track record is miserable of governments winning on that. Not objective. Again, coming from a planning background, we, as planners, we used to make all kinds of subjective decisions. Does a Walmart look good in a heritage area? that is a subjective decision. We also deal with developers all the time in a give and take. So maybe they'll give us some extra green space if we let them go 2 stories higher. And that's basically at the discretion of regulators, not an objective, arguably not an objective decision. Not established in advance, and I'm going to go into what that possibly could mean. Not as simple as possible. And as simple as possible sets an absolute value there. And you know, if you start at 0, not having any regulation at all would be as simple as possible. So Houston has no zoning whatsoever, and that would be pretty well as simple as possible as you could get. You can't cause undue delays. So you think about pipeline conflicts or any kind of environmental concern, causing undue delays by having public input or having an environmental assessment, and being unduly complicated. Well, again, this is in the eye of the panel. So I'm just going to go into a little bit of just one of these disciplines, and that's established in advance. What does that mean? Does that mean once the license is granted that the requirements cannot be changed? Or does it mean once an application is made, requirements can't be changed? Or does it simply mean that any re-regulation is a TISA violation because it's not established in advance? And so here we have the Mount Poly spill, which is described as the worst environmental disaster in my province's history. So 240 million cubic meters of spill from a mine with its tailings pond improperly built and bursting. So because my province has deregulated so far, they were in a kind of a scramble to undo this problem, and it became quite a reputational problem because people were saying, should you be approving any mines that can do this to the environment? So after the fact, the government of my province, British Columbia, imposed a whole range of regulatory requirements that were new, that were not established in advance. And this is not an atypical way that governments go about regulating. They make a mistake like this, and then they go, well, maybe we should re-regulate. And there are people who have applications in the pipeline, and they are affected. But under TISA, this could potentially be a violation of the agreement. So, I'm just going to put the questions if there's any negotiators here. When they say that something has to be as simple as possible, does that mean requiring environmental or archaeological assessments is a violation? Is requiring public input into something like pipeline development and consulting with First Nations, does that cause undue delays? Well, I think the question is asked and answered. Of course it causes delays, but who's to decide these are undue? And is public consultation in itself not objective? You're asking people for opinions, for their opinions of the development. So is that an objective standard? And I'm just going to conclude by talking about the right to regulate. TISA, like the GATS, may provide assurances that, about members' right to regulate. And this is often cited when we come up with concerns about the domestic regulation negotiations under the GATS. But panels have already decided or already ruled on the limitations to the right to regulate. They basically have said, if you voluntarily tie your own hands, we will not release you from those bounds. So this is a quote from the WTO panel U.S. Gambling case. Members' regulatory sovereignty is an essential pillar of the progressive liberalization of trade and services. But this sovereignty ends whenever rights of other members under the GATS are impaired. Thank you.